Welcome, everybody. It's good to see all of you tonight. We're glad you could join us on this evening. If not in person, then at least virtually we can come together up to hear this great presentation we have for tonight. Before I do want to welcome you all and just note that you've all been muted, but feel free to share your comments or your feedback in the chat. We'll be monitoring that as well in case you've got questions there. Again, we're so pleased to see all of you here to learn more about Minnesota's new criminal sexual conduct laws and the gaps that it will fill. This is quite a fitting discussion to mark the 16 days to end gender-based violence. We will be applying for 1 CLE credit for this presentation, and I want to remind you that we have many other great virtual events coming up, so please do check our website for more details on that. Now, before we begin, I just want to briefly mention how the advocates and our volunteers work every day to end violence against women and girls. We document survivors' experiences in the justice system through our local Watch project. We empower partners around the world with technical assistance. We strengthen laws that protect women and girls. You can support these efforts by making a donation. Simply text WOMENS, WOMENS, to 44321 or click on the link in the chat to donate. So without further ado, I would love to be able to introduce our speaker. We are really honored to have Karen here tonight and so excited to hear her remarks. Karen Long is an investigator with the Minnesota Department of Human Rights, where she addresses discrimination in settings such as the workplace, housing, or police interactions. She is actively involved in the pattern and practice investigation into racism by the Minneapolis Police Department. Previously, Karen has worked as a staff attorney at the Women's Rights Program at the Advocates for Human Rights. And before that, she was a prosecutor for nearly 20 years, focusing on gender-based violence, most recently at the Ramsey County Attorney's Office. So I would love to turn it over to Karen to start the presentation.
Thanks, Rose, and thank you, everybody, for joining us. It's always so important to mark the annual 16 Days Against Gender-Based Violence to remind us that it is an ever-present endemic in our society. And so I'm really happy to be able to talk about the work that I was able to be involved in over the last couple of years leading up to the last Minnesota legislative session. And just a little bit about the working group that I was involved in while working as the staff attorney in the Women's Rights Program at the Advocates. I was able to participate in a working group that met, as I said, over about 2 years to discuss some of the real gaps that we had found over the years as prosecutors, advocates, survivors, law enforcement, criminal defense attorneys, and other professionals who work every day with the legal response to sexual violence. And we had all known over the years that there were some gaps in our criminal sexual conduct statutes that needed to be addressed. And so we worked together to come up with language that we recommended to the legislature. And that language, for the most part, ultimately was passed. And so we'll be talking tonight about some of the specific pieces that we were able to put together for those changes. And I will note that I can't really see the chat very well, so I'm hoping that someone will let me know if questions come up. And then the other thing I always want to mention when I talk about these things is I will be talking about sexual violence. And so that can be either a range from uncomfortable to triggering for some people. And so I want to be clear that that's, I won't go into huge detail, but we will be talking about that naturally in order to talk about the legal response. So if I can go to the next slide. The first real gap that we wanted to address that unanimously we all recognized was the fact that in order to deal with the really common problem of addressing sexual violence that happens when the victim has been drinking too much, it's a highly common problem. And the statutes at the time, before we made the change, did not include voluntary intoxication. So in defining a person who is mentally incapacitated by either alcohol or drugs, that the statute previously only applied if that person had been administered the substance without their agreement. So for the far more common scenario, when the individual drank the alcohol intentionally or voluntarily and became intoxicated, prosecutors had a really narrow range of options to use in those situations. And so a case example, and the way I've kind of structured this presentation is to talk a little bit about what the problem was that we wanted to address, to give a case example that kind of illustrates the problem, and then to talk about what the solution was that the working group and the legislature ultimately came up with. And so the problem was not addressing voluntary intoxication, and when individuals take advantage of the voluntarily intoxicated person. And a case example actually was a case that was published by the Court of Appeals, where an individual was actually convicted at jury trial. He was a wedding photographer, and there was video from a surveillance video that showed the victim who was stumbling. She was sitting down at times, having trouble standing up. And this man went over to her and helped her stand up and sort of walked her stumbling over to his car, took her into the car for a period of time, and then took her back out to the lawn where she was sat back down again. She had trouble walking. And it was clear that she was very intoxicated. And he was convicted by a jury in that case, but the Court of Appeals overturned the conviction, saying that she had consumed the alcohol voluntarily. So our mentally incapacitated statute did not apply to her. What the prosecutor had charged and convicted the individual of doing was having sexual contact or penetration with a person who was physically helpless. And so the prosecutor was sort of relegated to using a physically helpless definition, which pretty much means you have to prove that he had sexual intercourse with an unconscious person or almost unconscious. And because this happened off camera and in a car, where, of course, most sexual violence happens in private, the Court of Appeals said that we were not able to determine whether the woman was physically helpless at the time of the sexual violence. And so no statute applied ultimately. He ended up getting convicted of a gross misdemeanor, which actually we'll talk about a little later. So if we can go to the next slide. The solution, after much debate, much back and forth and debate, and looking at a number of different statutes around the country, is we added a definition to the mentally incapacitated statute in Minnesota. So the subdivision 1 was the existing language that talks about administering without their consent, but we added the language under subdivision 2, which includes that a person who is simply under the influence of any substance to a degree that renders them incapable of consenting, in other words, providing a knowing, intelligent consent, or renders them incapable of appreciating or understanding, controlling their conduct. And so this gets at both the mental incapacitation that happens when a person drinks too much and also the physical incapacitation that happens without having to prove unconsciousness. And so we hope that this, and by the way, this statute only applies if the offender or the defendant knew or should have known that the victim was in this state at the time of the sexual conduct. And so we hope that this will have a broader effect to capture drunk sexual violence, which is a real problem. So if we can go on to the next slide. The next problem that we wanted to address, and this is kind of my baby in a way, because I have a really good friend who is a housing attorney, and she and I had talked over the years. I was a prosecutor; she was doing housing discrimination law, and she talked a lot about how it was really common that landlords were sort of preying on individuals who are vulnerable because they don't have a lot of options about where they can live. They might have a criminal history of some kind that makes it hard, or eviction history that makes it hard for them to get housing, or simply not enough money, not enough housing, as we know. And so there was all this exploitation happening by landlords. And so we decided, in this working group, we decided to have a conversation about broadening the concept of extortion or coercion that happens. It isn't always physical. So typically our sexual assault statutes address physical coercion, force. We all know forcible rape is against the law. Manipulating children into sexual acts is obviously against the law. But there are ways that adults can also be manipulated and coerced that are not necessarily physical. And so, I don't have a specific case example, but there have been a number of lawsuits over the years. And actually, there was just a settlement recently with a number of residents who complained about landlords who were exploiting them by demanding sex in return for rent, or demanding sex in return for not being evicted, using the key. I mean, when somebody has the key to your apartment and they can come in anytime, that's a pretty vulnerable situation when you really don't have options to move. But we had further conversations. And so if we can go to the next slide, there are lots of ways that folks can be coerced into sexual conduct that they don't agree with or want, but they feel compelled to do it in order to protect themselves from other problems. So you can see we came up with 6 circumstances where somebody might be coerced and exploited into sexual conduct that they're compelled to do. So, for example, if sexual harassment is and these only apply, by the way, if the sexual conduct happens. It's not just the threat or the request. It is only if actual sexual conduct, penetration, or contact happens. And somebody threatened to harm or withhold the person's employment or their business or profession. We know that sexual quid pro quo, sexual contact happens in employment situations sometimes. Threatening to make a criminal charge against someone, even if it's not true. Threatening to expose the person's immigration status. And I had good conversations with our immigration specialists or at the advocates who were able to help me with good language to make sure that was an accurate way to talk about a threat to expose immigrant status. The threat to disseminate private sexual images in return, in exchange for not, in other words, demanding sexual favors in exchange for not sharing someone's private sexual videos or images. And then a threat to expose information that the actor knows that the complainant wants to keep confidential. What we were aiming at here is there are folks who threaten to out folks in the LGBTQI community if they don't perform sexual favors. And of course, it can be a very coercive situation in many communities. And then, of course, the threat to withhold someone's housing or change the cost of housing in return for favors. And so our hope is that this captures a more sort of 21st century understanding of the way that sexual exploitation and violence can happen. It doesn't always require physical threats. So we can go to the next slide. The next one that I wanted to talk about was the narrow way that prosecutors have up until now been hemmed in by the statutes that address position of authority for teenagers and adults. So the age of consent in Minnesota is 16. There's generally no prohibition against teenagers who are 16 and above agreeing to sexual relations. But there are a couple of exceptions to that. One of which is where an adult is in a position of authority over that teenager. So if they are the manager at work, if they are the counselor who goes on a camping trip, if they're the clergy or that kind of thing, or if they're an educator and they are in a position of authority, that was always criminally prohibited. But the problem became there are some situations in education settings where educators might have access to teenagers, but they're not necessarily in a position of authority over that teenager. So the case example I can give you is a case where I, as a prosecutor, had to decline criminal charges, even though I tried really hard to find a way to charge this individual, but our statutes just didn't apply. So I had a case come in where there was a 17-year-old girl, and she and her friend were volunteering at a separate elementary school just for some volunteer hours. They were working with an elementary school teacher. And while the teacher of the classroom would be considered a position of authority because he could tell them what to do and when to come and go and all that, there was another teacher down the hall who would come in and sort of flirt with this girl and engage with her and begin sort of grooming her for some manipulation. And eventually he took her on a tour one day of the school. And when he went into his classroom, he unzipped his pants and had her perform a sex act on him. He was in his 40s. This girl was 17. And the only reason that he had access to her is because she was a student and he was a teacher, but he wasn't her teacher and he wasn't in a position of authority. And so ultimately, we didn't have a statute she sort of complied with what he did. He didn't force it physically, but I felt like it was a very wrong situation. It just wasn't covered by the statute. And there are numbers of case examples like that, where a coach from another team might start texting and getting to know the student at another school and then engage in sexual behavior. And so we wanted to talk about prohibiting all educators from having sexual conduct with students that they met because they are educators. So if we can go to the next slide. The solution that we came up with was to broaden and more specific, instead of saying more generically adults in a position of authority, we wanted to have an educator-specific statute that says that the professional role of an educator makes them unable to have sexual relations with kids. And so there are different ranges of how it applies. The first one is for students who are at the same school as any licensed educator, regardless of how old the educator is and regardless of how old the secondary student is. Because previously, those statutes only applied if the teenager was a minor, was under the age of 18. But we know that most people turn 18 when they're in high school, and many turn even 19 or 20 if they are in a special education class, or if some English language learners turn 19 or 20 when they're in high school still. So we wanted the law to apply even if they had already turned 18. And so the first provision says that any licensed educator, regardless of how old they are, is prohibited from any kind of sexual conduct with students at the same school, regardless of how old the student is. The next provision applies to other staff who are not necessarily licensed, because we know that there are cafeteria workers, there are maintenance workers, there are contractors who come into the school to do, to fix the lights or something. So anybody who's contracting or employed, if they're over 18 and at least 48 months older than the student, they also would be prohibited from any kind of sexual conduct with the students at that school. And then finally, the broader prohibition is for educators who are licensed and they're over the age of 18, and they're at least 48 months older than the student. Again, even if the student is an adult, if the educator is licensed and more than 4 years older, they are prohibited regardless of whether they're at the same school. So again, if the coach is meeting different students from different schools, if the history day, person who's just on staff for History Day or something gets to know some other students, again, that prohibits any sexual relationship from happening. And so that felt like a much broader, and actually I would say that the educator MEA, or the Education Association, wanted it to go even farther. I think they didn't even want the 48-month provisions and that kind of thing, but we wanted it to be very clear that these are people who have a lot of sway and a lot of authority over these students, and we want them to be clear about what their role is, and that's not to be dating students. So let's go on to the next one. So in the case that I talked about a little while ago involving the wedding photographer who took the drunk woman into the car, what he was ultimately convicted of, he had penetration sexual intercourse with that woman. But the only thing that applied at the time was a gross misdemeanor, 5th degree criminal sexual conduct. And you might call that sort of a groping offense. So it is a non-consensual contact that happens with the private, intimate parts, but not involving any kind of force or violence, not involving drunkenness, not involving somebody who's too young. So it really is the bare facts, or the bare elements are just non-consensual sexual contact. And for those people who experience that, but it's a penetration offense rather than a contact offense, of course, they felt like equating the two didn't feel right. It felt a gross misdemeanor to them, felt like it did not recognize the seriousness of a penetration offense that happened. And so we wanted to have a conversation about having a felony level penetration offense that didn't require the state to show the other things like force or drunken, intoxication, or children who are under the age of consent. So, and I did a study when I was at the Ramsey County Attorney's Office where I did a wide review of a number of criminal sexual conduct case reports to police. And about 26% of those cases involved a penetration offense that didn't have the elements of force or coercion or intoxication or other things. So it was a pretty common scenario, because we know that a very frequent response to unwanted sexual touching is freezing. So victims frequently experience a freezing reaction. And so a case example would be, as we were talking about this potential change in the law, a friend of mine who I'd worked with at the Ramsey County Attorney's Office called me and said, I have this case and I want to charge more than a gross misdemeanor, but talk it through with me and see if we can find something to charge. And in that case, it was a 17-year-old young woman who had gone over to a neighbor's house. He was a little older. They were going to watch some videos. They were sitting there. She was not drunk. He did not use force or violence to engage in sexual touching, but he sort of quickly reached over and engaged in sexual touching with her that turned into penetration. She froze. He didn't pin her down. He didn't threaten her. He didn't use a weapon. She wasn't drunk. She was of age. So none of the other felony level elements would apply in that situation. And the prosecutor felt, and I agreed with her, that this gross misdemeanor sort of groping offense was ill-suited to what had happened to this woman, but it was really all she had. And so that's what she was able to charge in that case. And so if we can go to the next slide, our working group came up with language that the legislature passed that creates what we called a felony 5th degree. So it is a 5th degree criminal sexual conduct, but where penetration occurs rather than mere contact. And I never want to I by no means am I saying that sexual contact that's unwanted is no big deal, but the penetration offenses tend to be more violating, and people feel like that gross misdemeanor is not enough. So this is a 2-year maximum felony. It's not typically for most people going to mean prison. It's going to mean probation, but a 2-year term rather than a 1-year term. And it is not a registration offense. So it doesn't require registration, which is fine, but it recognizes that the penetration that's non-consensual is more serious than the contact. Doesn't mean that obviously a forcible pinning situation or threatening situation would be a higher level felony, and that already existed. But this is for just the non-consensual, where we don't have the other elements to prove there. And so can we go on to the next slide? One of the really important conversations that came out of the working group was the large number of people who are concerned about how broad Minnesota's predatory offender registration statutes are. This is sort of more commonly known as registering as a sex offender, but it's called predatory offender in Minnesota because it applies, right now it applies to all felony level criminal sexual conduct offenses, except the one we just talked about because it was specifically exempted. And it applies to juveniles who are charged with felony level criminal sexual conduct. It also applies to kidnapping and burglary, some forms of burglary. And so it's a pretty broad net. And there is a discussion happening right now whether the requiring all those people to register as predatory offenders, whether that really provides the amount of safety that counterbalances the oppressiveness of being required to register for a minimum of 5 years. In some cases, it's 10 or even life. And so part of this package that was put together by the legislature will convene a predatory offender working group that funds another working group to specifically talk about the registration statute and allowing potentially more discretion, because as it is right now, neither prosecutors nor the court have discretion to not impose registration. If a person's charged with a felony criminal sexual conduct, they have to register, even if they're not convicted of it. If they're convicted of something else in the same behavior, but not the sexual violence, they still have to register, and no one has any authority to get rid of that. So this working group will be meeting and will be discussing proposals to, make sure that predatory offender registration only applies where it's needed to provide community safety, but doesn't go so broad as to capture those people in its net that are not really, that law enforcement doesn't necessarily need to be monitoring their addresses. So that was a really positive outcome of that working group. And can we go on to the next slide? I want to mention just a couple of things briefly. I want to leave time in case people have questions, but a couple of other things that got changed in this last session out of the work of the working group was to clarify that sexual abuse of vulnerable adults that happens typically in nursing home settings, that had been defined as a form of vulnerable adult abuse as a gross misdemeanor rather than criminal sexual conduct. But of course, it really looks much more like the other types of professions. Physicians can't have sex with their patients, psychotherapists can't have sex with their patients, and people in nursing homes should not, the staff should not be having sex with patients. And that's should be considered to be a form of criminal sexual conduct. So that was changed. The new language in this new set of statutes, when people have sexual abuse of children, the age of the child determines how severe the offense is. And so this change would group 14-year-olds who are 8th graders with 13 and below. So previously, the cutoff age had been 13 for the most serious level of offense, but now it's 14. So they're being treated more like the children that they really are. And then for significant family relationships, where kids are 16 or 17, they're of the age of consent, but not if the adult partner is a significant family member, meaning they either live in the same household or they are a grandma, a parent, cousin, that kind of thing. But this addition says that the parent's boyfriend or girlfriend is also considered to be a significant family relationship that is prohibited, even if the teen is sort of willing. We see far too many of those types of exploitation of teens. And then it gets complicated to explain how this works, but for teenagers, an individual who is less than 10 years older than the teenager can say, oh, I didn't know I was having sex with somebody who was too young. I made a mistake of age. And the new language reduces that gap, that age gap, from 10 to 5. So it reduces the number of people who will be able to say, I made a mistake in the age of the teenager. I thought they were 16, but they were only 15. And so it reduces the number of cases of adults who can engage in sexual abuse of minors and claim a mistake. So those are quickly some of the other changes that we made. And then I wanted to just mention, if we can go to the next slide, these were not necessarily part of our working group, but they're relevant to this subject. There was a group that worked for many years and was successful this last year in eliminating the statute of limitations for criminal sexual conduct. And so we know that people are obviously, trauma takes all kinds of forms, and it takes all kinds of different situations before people can come in and report a criminal sexual conduct offense. And so this change simply says that, like homicide and kidnapping and some of the other really serious offenses, there's not going to be a statute of limitations for criminal sexual conduct. It will not be retroactive. It only applies to those offenses that are happening now and forward. But it will allow for people to come in years later. And the most typical way that this will really be beneficial, I think, is where there is an individual who has been sexually abusing a lot of people. And when they sort of get themselves together and realize that there is a group of people, it will allow prosecutors to address that, as we saw with, for example, Bill Cosby, Harvey Weinstein, and others, where now all of a sudden it becomes known that there are a number of victims. This will allow that to be prosecuted rather than have limitations happening. So, and then we all know that Indigenous women and also African-American women are at high risk for sexual violence, enormously higher risk than many others. And the missing women and murdered women from those groups often go without the proper level of investigation, without the proper level of I don't know what I want to say, but there has been a complaint over the years that those cases are treated sort of with less dedication of resources and concern. And so there have been 2 task forces formed to go back over these cases and look into it and make sure that there is a strong dedication of resources to look into the missing and murdered women from those groups. And so that seems like a really kind of quick, dense discussion of what we did. There were some other things too. I won't belabor that, but I'd love to open it up for any kind of questions or comments if people have them.
Well, Karen, I'll start with the question. As you were doing this work and you came up with the new law, which is terrific, thank you so much for this tremendous contribution to changing our laws. Where does Minnesota rank, in your opinion, compared to other states with these laws?
Well, for the most part, Minnesota does really well when it comes to gender-based violence. There's always room for improvement. I don't want to say that there isn't, but we were definitely behind on the whole issue of intoxication. That, the fact that voluntary intoxication was not covered in our statutes is pretty concerning. And I think when it comes to some of the educator pieces, that we were a little behind on getting up to speed on that. But for the most part, Minnesota tends to be a leader on these issues. I do think that now this sexual extortion, new provisions are actually kind of groundbreaking. We found something similar in Pennsylvania, and I think Georgia had something kind of similar, but we actually were drafting things brand new without even really having much to go from the other states. So that's actually, we're on the cutting edge on that. So it's kind of a mixed bag, I guess you would say. But in terms of training and resource and advocacy, Minnesota definitely is a leader on the issue of gender-based violence. I see a question, any information on whether the new laws have already made a difference in the number of perpetrators? I don't know the answer to that. I have to admit, I'm a little bit out of the loop. I should check in with some of my prosecutor friends and see if they're using these new. I have to believe that the voluntary intoxication one has come up. I mean, I can't even believe that that hasn't been used already, but I will have to ask around and see whether people are using some of these new offenses. Probably depends on which ones.
I had a question on the housing extortion component, and if I know we talked about that and some of the immigration provisions, which yay got included. Thank you. But did you work with other people in the housing rights community, and has there been much outreach to people in housing justice around that and into kind of shaping that, and what more kind of visibility needs to be made there, do you think?
Yeah. So the first part of the question having to do with who we reached out to, we communicated with a number of different housing legal aid, Homeline, and a number of the housing organizations who work with tenants to provide them resources. And we also worked with and spoke with the navigators in the city of Minneapolis. Has housing navigators who are specialists in being sort of a liaison between tenants and landlords to help ensure success in housing, because we want people staying in their housing. And so to a person, every lawyer and advocate in the housing community that I spoke to was really excited about it. They had seen it repeatedly as a problem. I talked with a group, or a housing navigator when I was at the Advocates, who had met with and spoken with a group of women who were complaining about the same landlord doing these things. And so the housing advocacy community was really happy to see this. And some of them couldn't believe that it wasn't already a crime. And so that was a very positive response. And in terms of outreach, I would say, again, I'm not aware specifically. I know those navigators in Minneapolis are aware of the changes, and some of the lawyers are, but it would be really great to see some level of training opportunities or public awareness opportunities. And I don't know if that's anything the advocates would ever want to get involved in, but that definitely probably is still out there as an opportunity because, as you know, the legislature does a lot over the year, and there was a lot going on this year with COVID and the eviction restrictions and that kind of thing. So it is entirely possible that there's a lot of landlords and tenants out there who don't know about this change. So I would certainly, and I'd love to be part of that if that ever happens. I don't know that I can make it happen as part of my new role in my new job, but I would certainly be part of anything the Advocates wants to do to spread the word, because I agree. And same thing with the issue of threatening to out immigration status. And there's probably a lot of communities that could benefit from hearing about those changes. So, yep.
Carmen, I have a question. So there's a lot in the news about sexual assault on college campuses. Does this change what is being taught during orientation? Is that being updated? Is there any outreach to campuses?
Hi, Tekla. It's nice to see you. Yes, I think a couple of the things that we've talked about tonight could impact college students. So obviously the voluntary intoxication provision is going to come up more frequently in that younger population. So certainly I would hope that college campuses are making students aware of that change. And the other one is the non-consensual penetration change that happened. We do have an affirmative consent standard in Minnesota, meaning that consent only, sexual conduct can only happen if there is consent, which is a knowing and present agreement to sexual conduct. And so the second part of your question, whether there's any outreach happening, again, I'm not aware of that. I've not been asked to be part of that, but I certainly would love to be and would love to see that, because I do think it's an important piece that especially college students who are sort of new to the whole thing about adulting and how do people behave and interact, especially around alcohol, would make a lot of sense to make sure that they are aware of these provisions, because of course we want it to not happen. We don't want to have to use the statutes. We want it to not happen. And so the more information, the better, I always think. So Katie is commenting, they've recently added criminal sexual conduct seminar to their orientation program. Yeah, and I feel like leaving it at freshman orientation is also not sufficient. It sure would be nice to have more of it, because we all know most employers do sexual harassment training every year to remind everyone what the law is. So it certainly would make sense to do that on college campuses too.
Well, Karen, I will give you a virtual round of applause for such a great and rich presentation again. And thank you for this incredible contribution you made to be able to change Minnesota's laws and give greater protections to victims and survivors. We so appreciate it. And we're looking forward ahead to the future. And I'm so glad to hear what we have to look forward to with this. So I just want to thank all of you for joining us tonight. If you want to support our work to protect women's human rights, please donate. You can just text the word women's with an S to 44321 or click the link in the chat to give. Thank you for joining us today. And thank you so much for being a part of the human rights movement.